For the second part of our program, we're going to speak with Professor Erik Luna. You know, it's kind of an interesting thing. Tomorrow, I guarantee you, a lot of people are going to ask me, Vikrant, you had this big summit, what did it accomplish? And the honest answer tomorrow is going to be, I don't know. But the answer in the long term, hopefully, is we developed projects, we developed research proposals, we developed all kinds of new relationships and things that came out of it. And I can sincerely say that one of the most important and exciting things that came out of the summit that we did 2 years ago in New Orleans is the Academy for Justice, which is a project that Erik leads and that he's going to talk with us a little bit about this afternoon. I'll tell you a bit about Erik before we bring him out. He's the Amelia D. Lewis Professor of Constitutional and Criminal Law at Arizona State University. He has received 2 Fulbrights and has taught in New Zealand and the United Kingdom. He actually has a lengthy international resume, which I wish I could tell you guys all about, but we're just limited in time here. He's previously taught at Washington Lee University and the University of Utah Law Schools. He is a member of the American Law Institute. He's an adjunct scholar at the Cato Institute. He is a former prosecutor in the San Diego District Attorney's Office. I think that's always an important point, that people who are talking about criminal justice reform have backgrounds as prosecutors. He holds a bachelor's degree from the University of Southern California and a law degree from Stanford, and I'm pleased to welcome him to this stage. Please join me in welcoming Erik Luna.
Great, thank you.
All right, Erik, so we're going to talk about Academy for Justice. We're going to talk about the book that the Academy for Justice has developed. So what is the book and what's it about?
You bet. Reforming Criminal Justice is a 4-volume report authored and reviewed by leading academics in criminal law and other disciplines. The contributions describe the need for reform in particular areas of criminal justice, and they suggest policy recommendations to make those changes. In particular, the report seeks to make the relevant law and literature accessible to those who might use it, who might actually use it in making change in the criminal justice system.
Actual policymakers, legislators.
Like those in the audience.
Yeah.
The report's primary audience, these individuals who can make this change, are no doubt policymakers, people at think tanks, but also the average citizen who happens to be interested in criminal justice reform. So the idea is to fortify the criminal justice reform efforts that are currently afoot in the United States with the research and analysis of respected academics. And in this way, the report hopes to increase the likelihood of success when a given reform is brought up for debate, or it's put to vote, or it's otherwise considered for action, and then actually implemented in the criminal justice system. So by connecting the world of academics with real-world policy and practice, it's hoped that we can bridge the gap between scholarship on the books and the reform of laws on the actual ground.
Okay, so what's the format of the book?
The report is composed of 57 separate contributions. It's an immense project covering the entirety of the criminal justice system. It totals over 500,000 words. And I got to read each of those words several times.
You edited every chapter?
I did.
Wow.
Had some help, no doubt, but I had the pleasure of being able to read those contributions. But for ease of use, the report is divided into 4 separate volumes and then separated into or divided into separate chapters. And by and large, each chapter runs between 5,000 and 15,000 words, and it's intended to be easily understood and used by professional and lay readers alike. If you don't mind, I'll go in to tell you a little bit about the volumes.
Please,
yeah.
I'd love to hear about it. Yeah.
Volume 1 introduces criminal justice reform as an idea and the justifications for it, and then it analyzes various issues that might fit within the heading of criminalization broadly conceived. So it includes topics like overcriminalization and overfederalization, the use and abuse of misdemeanors. It has several chapters on drug prohibition and issues of legalization. It takes on topics like sex crimes, firearms, gangs, and the criminal aspects of immigration. And it finishes up with chapters on what might be called pan-systemic issues, things that go across the criminal justice system in mental illness and juvenile justice. Volume 2 examines some of the most critical issues in policing today, and it includes the decisions to investigate particular individuals, the role that race plays in those decisions, and the methods of obtaining evidence that is then used at trial. So it has chapters on front-end democratic accountability in policing, as well as back-end legal remedies for police misconduct.
Some of the things Barry Friedman was talking about this
Absolutely.
morning.
By the way, Barry is the author of that. I was very fortunate enough to have Barry as the author. I feel a little bit like Fannie Hall and Marshall McLuhan. I'll just bring him on up here. It has several chapters on race in policing, which is obviously a very hot topic. It includes topics like a chapter on racial profiling and stop and frisk and the use of force. And then the volume discusses some of the means of gathering evidence. It includes high-tech methods, particularly the use of databases by the police, but also some standard traditional methods that are obviously still used today, like interrogation, eyewitness identification, and the use of informants. The third volume deals with issues of adjudication, beginning with the mysterious institution known as the grand jury, right? And the underappreciated decision to detain individuals prior to trial. It has several chapters on prosecutorial discretion and issues like plea bargaining and charging. It deals with problems of indigent defense and the discovery of evidence at trial, the use of forensic evidence and the phenomenon of wrongful conviction. There are also chapters on racial equality in the system and the rights of crime victims. And the volume concludes with pieces on corrections of errors on appeal, and also the specialty courts, the problem-solving courts that have become very popular in recent times. Yeah. The fourth and final volume deals with the rationales for punishment, the types of penalties, the sentencing schemes that exist, the current state of incarceration and the conditions of confinement, and the prospects for inmate release and integration. It begins with the rationales for punishment, retribution, deterrence, incapacitation, and the failures of modern sentencing schemes under these theories. It discusses the resulting mass incarceration of millions of Americans, the problems of racial disparities, and the prospect of reducing incarceration through risk assessment. There are chapters on sentencing guidelines, on mandatory minimums, on economic sanctions, on community punishments, and even the death penalty. The volume also has chapters on the conditions of confinement, which is obviously a very important topic, the difficulties faced by prisoners with disabilities, and the possibility of correctional rehabilitation. And it concludes with chapters on reentry, collateral consequences, and clemency. Although there is a diversity among the chapters, the authors were asked to do certain things in each of their chapters. So they were asked to state up front the concern in that chapter and why it makes sense to regard that as an issue deserving of reform. They were expected to lay out the law, the policy, and any other information that would allow the reader to have a sufficient or at least a passable understanding of the chapter topic. The authors were also asked to review the literature and any important research that has been done in that topic area, with attention to those works that critically analyze and assess the problems that are raised by the chapter topic. And then the authors were asked to provide reform proposals, which I think is an important contribution.
Anybody can criticize, but you've also got to...
You have to actually, sometimes academics are not so good at the second part, but that's what ultimately we would be looking for, is what are the, what can we take away from this? What type of proposals could we put before policymakers today? Yeah.
Huh. So I can't ask you to go through all 57 biographies of all 57 chapter authors, but tell me a bit about who's involved in the Academy for Justice and who these authors are.
We had about 60 authors, and we had another 60 distinguished reviewers who collectively constituted one of the most remarkable groups of criminal justice scholars to be brought together in one venue. To some extent, I think it was almost a veritable who's who's list of criminal justice scholarship, literally from A to Z. You had Professor Albert Alschuler, and you had Professor Frank Zimring. And there were others. There were legends of criminal justice, and some I think that the members of the audience will know, like David Cole and Frank Cullen and Barry Feld and Jeff Fagan and John Monahan and Stephen Morse and Daniel Nagin and Michael Tonry. There were also quite a few what you might younger or mid-career scholars, like Doug Berman and Paul Butler and Paul Cassell and Barry Friedman and Brandon Garrett and Nancy King and John Pfaff, Dan Richmond, Stephen Smith, Carolyn Jordan Steicher, the chapter on the death penalty, and Ron Wright. And then there are some rising stars whose names may not be recognized by the audience, but you're going to be hearing a lot from in the coming years, like Beth Colgan and Megan Stevenson and Sandy Mason. So it's a really exciting group of folks who were brought together to deal with this the important issue of criminal justice reform and to produce this volume.
Are they all law professors? Is everybody a lawyer?
No, although there are a lot of law professors, let's be clear. The participants come from numerous disciplines: criminology, criminal justice, economics and statistics, social work, sociology, psychology, psychiatry, public administration, philosophy, political science. But to be honest, there are lots of law professors involved, and that's hardly surprising given the endeavor, which is to reform some law and legal policy. But to be clear, many of these law professors, they have PhDs in the primary disciplines and are considered experts not just in law, but in some other discipline as well, whether it's sociology or psychology. And you have to keep in mind that law is an inherently parasitic discipline. Think of law and economics and law and psychology. And law professors who specialize in criminal justice tend to be the most interdisciplinary of all academics.
That's true. And we're allowed to be mean to lawyers because we are lawyers.
That's right.
Well, let me ask you this. So you've got all these law professors. You mentioned a lot of these doctorates. There is a tendency in the academic community to write in jargon and to just be writing for each other. And the book, frankly, is not going to be useful if that's what's going on. So what did you do to encourage accessibility?
Yeah, well, that's exactly right. Traditional academic authors write primarily to themselves, that is to other criminal justice scholars, not to the public or to policymakers or professionals or policy analysts or those interested in criminal justice more generally. As a result, criminal justice scholarship has tended to be inaccessible in a dual sense. It's dense, it's filled with jargon, it's as a general rule, painful to read and unfriendly to normal human beings. Oftentimes, scholarly works are also physically inaccessible in the sense that they're published by academic presses and journals and buried in the bowels of libraries or hidden behind paywalls. So the report is specifically intended to counter this. It's intended to be accessible in both senses. It's supposed to be available to everyone, readily available, and we've done that with a dedicated website. And the prose is not supposed to be loaded with legalese or its nerdy academic cousin, academese. As mentioned, each chapter is relatively short, and it's intended to be easily understood and used by professional and lay readers alike. And they were, the editing process was tried to make each of the chapters and the chapters within the volumes thoughtfully organized and free of unnecessary nuance and jargon. The editorial process emphasized clarity and comprehension. That was the pole star of this entire project. So for what it's worth, to expedite the review, we created basic grammatical conventions. We had a style guide, the editing process. It involved a real balancing act. We wanted to try to maintain a fairly consistent style while also maintaining and preserving the voice of the individual authors. Ultimately, the goal was to make sure that we communicated clearly to a non-academic and possibly non-legal audience. This didn't mean reducing things to an elementary level. But instead making sure that an audience could understand this and could understand it on a first read. We recognize with busy professionals like those here in the audience that there probably wouldn't be a second read. So we hope that this report, it will serve its probably the most daunting task, I think, facing criminal justice reform advocates like those here in this room, which is the gap in knowledge that exists between the general public and even among government officials with regards to criminal justice and criminal justice reform. what is needed is a means to help people appreciate the criminal justice system, to understand its processes, to understand how they're interrelated, and so that they can have a full and thoughtful discussion about those issues and perhaps look for possible solutions. And this is where I think academics have an actual role to play. Our work product, what we do, is fundamentally all about reform, although it's not always labeled as such. Criminal justice scholars spend their entire lives studying, critically analyzing, and writing at length about crime and punishment and processes, all with the goal of some greater understanding of the system, and thinking about potential reforms, changes that should be made to that system given any problems that exist. And not least of all, our primary responsibility at a university is to teach. And my hope is that the experience of our day job, talking about the criminal justice system, trying to make it understandable with our students, allows us to help the American public understand the difficulties and complexities of the criminal justice system as well. And I'm excited that this particular project, that many of my colleagues involved in the report are here in this audience, and we may see them hopefully attending important conferences and summits like this, rather than simply going through the typical academic circuit.
Sure. Well, another element of accessibility is just the topics you choose.
Right.
There's a joke from Chief Justice John Roberts. He'd said that a lot of these law review articles are about things like Immanuel Kant's approach to evidentiary law in 17th century Bulgaria.
Yeah.
He said, why is that useful to me right now? And you guys have really chosen topics in policing and in corrections that are relevant to public policy debates today.
Yeah, absolutely. That was part of our goal in thinking about the topics. Now, I had to draw upon my colleagues. I didn't trust myself just simply to come up with the topics. So the idea was to come up with a series of issues, not only that are criminal justice reform topics that are of great importance to the people who are here in the audience, but ones where this scholarship could have a meaningful impact, that there's something to say that maybe those in the reform movement or average citizens or lawmakers, they didn't quite know. And so I think we didn't hit every issue in criminal justice, nor would have that been possible, certainly on the first go-around. But I think we hit many of the most important topics and began the process of this discussion, this bridging the gap that exists between those in the academic world and those in the real world.
I want to follow up on an interesting idea there. You said, essentially, there would be no need for a project like this if everybody knew all the same things, but you seem to think that academics have some unique perspective or knowledge that others don't fully appreciate. So let me ask this question two ways. What do the academics know, almost all of you, that the politicians don't quite get? And then let me ask you, what do the academics know that the advocacy community, the kinds of people in this crowd, don't quite get?
Okay. As to the first question,
yeah.
I would point to the really exceptional chapters that in the report that deal with the reason we punish to begin with, the justifications for punishment. Politicians often assume that incarceration equals deterrence, that by incarcerating more people or incarcerating them for longer periods of time, you're going to reduce crime. But the empirics don't actually back that up. So Daniel Nagin, in his chapter on deterrence, shows that lengthy prison sentences cannot be justified on the basis of crime deterrence through imprisonment. And the empirical evidence does not support the idea that harsh mandatory sentences will serve that function. Another chapter by Sean Bushway on incapacitation shows that it's difficult, if not impossible, to justify these extraordinarily harsh sentences based on the incapacitative effect of incarceration. If anything, the case for a lengthy prison sentence has to rest on retribution, on retributive considerations. But if you read Jeff Murphy's chapter on retribution, you'll understand that the theory of just deserts can't justify draconian sentences, particularly mandatory penalties. More than anything, retribution provides a brake on sentencing. It's not a gas pedal. So pass your new lengthy mandatory minimum if you must, Mr. Lawmaker, but stop claiming that it's necessary for deterrent reasons, for incapacitative reasons, or that the theory of just deserts would call for that particular punishment. As for your second question.
Yeah. You might offend some people in the room.
Oh, maybe. I might. Let's take the flip side.
Okay.
Incarceration as a sanction is not some vestigial part of the criminal justice system, like the human appendix, right?
Mm-hmm.
That can be gotten. We can get rid of it without any consequence.
Excise it,
right?
Yeah. Mm-hmm.
Incarceration has a role, and I don't know of any serious academic scholar who believes otherwise, save for maybe some Scandinavian penal abolitionists.
Right.
What is well recognized, both by academics and by people in this room, is that we use we use incarceration way too frequently. It is our first instinct rather than our last resort. If we put resources into empirically supported programs, we can avoid some of the socioeconomic and human costs of imprisonment through, for example, non-custodial sanctions, which is discussed in Michael Tonry's chapter on community punishments. We can also be smarter about who we incarcerate and for how long. This is explored, for example, in John Monahan's chapter on risk assessment in sentencing. And we could also take a look at the old adage that many people in this room, and I'm sure you remember, nothing works. That's Robert Martinson's claim from the 70s, which essentially scored the end of, for a while at least, rehabilitation as one of the goals. Read Frank Cullen's chapter on correctional rehabilitation. There are things that can be done. There are programs that work. And more generally, there are academics who are doing the studies right now. They're doing the research. What we need is to bridge the gap between the scholarship that exists, the work that's being done, and the actual policies that are being implemented.
Huh. I'm wondering if the book has a political or philosophical bias. Bias is a pejorative term, let's say. Does it have a perspective?
I don't think so, and that was important not to do that, in my perspective. In fact, we have in the very beginning, in Volume 1, we have two keynote speakers. We had a major conference in February at my home institution, Arizona State University, at the College of Law, and we had two keynote speakers, one on one night, one on the other. The first speaker was Justice Clint Bullock, who is a extremely well-respected litigator, a right of center, a classical liberal.
Institute for Justice.
The Institute for Justice, also was the head of litigation at the Goldwater Institute before he ended up on the bench, and he's now one of the, what I think is one of the rising stars of Republican jurists in the United States. So he gave the keynote. The next night, we had David Koch give the keynote. And David Koch, as many in the room know, he's a public intellectual, a distinguished law professor at Georgetown, and he's also now the legal director, I believe, for the I can't say what the exact term is, but the national legal director, I believe, of the American Civil Liberties Union. So the idea was that we had individuals both from the left and the right participate. The politics was not the goal. It instead was trying to serve the good end of criminal justice reform, regardless of the political ideology. And
Justice Bullock has a chapter in the book, I believe.
He does. He gives an introduction.
The introduction.
It gave his keynote is the first piece in there, and it's lovely. It's really terrific, and I'm very pleased to have both Justice Bullock's piece and David Koch's piece to introduce the volume.
Tell me a little bit just about the genesis of the book. How, where'd the idea come from, and how did it all come together?
Yeah, and I think you mentioned this in your opening remarks. It actually started at the last summit in New Orleans, the wonderful summit that was held by the Charles Koch Institute, and I started talking with you, some of your colleagues, particularly Alison Kasich, who has been a real leader on this, and the question was, why aren't academics more involved in the criminal justice reform movement? Now, that's not completely true. That's not unconditionally true. You take a topic like wrongful convictions, and academics have been heavily involved in it.
Sure.
But there are a lot of issues in the criminal justice system, and a lot of issues that are subject to debates with regards to reform, where academics haven't played much of a part. And like I said, there's something strange about that, since that is what we do. Whether we call it as much or not, we do think about the criminal justice system, both individual parts and how they work together. And our scholarship spends a lot of time thinking twice about those parts or the system as a whole. And so the idea was, what if we were to get together the best and brightest, the cream of the crop in terms of academics in the criminal justice sphere, bring them together, invite individuals to write chapters on topics within the criminal justice reform movement. We ended up forming 4 volumes divided along the lines that I described. In what I described as academic speed dating, we had this conference where all of these chapters had an opportunity to be workshopped and an interaction with some of the best and brightest of academe. And then we went through a long process of editing. I was actually in the United Kingdom this summer, and I spent most of it on U.S. law, which is, there's something strange about that. But it was I spent a lot of time working on it, and it was a pleasure to be able to work on the individual chapters written by such a distinguished group of scholars. And then ultimately, the past month or so, we've been working on the publication process, and now it's complete and the report's out.
What are you doing to get it in front of people? Obviously things like this, but what other endeavors out there so that it's not just tucked away in some law library?
You bet. Well, the main vehicle by which this report can be accessed by anyone is online. We have a dedicated website, academyforjustice.org, where all 4 volumes are available. The individual chapters are available. You can see the participants. We have some information for the media as well on there. So it's with that goal of accessibility, we've put together this website precisely so that people will have ready access to the report and its contents. And
you're on a bit of a speaking tour for the book too?
Probably.
Yeah.
I'll have to talk to my wife about that, but yeah, certainly. And I'm very fortunate to have such a great group of colleagues who contributed, and I'm hopeful that they will participate as well and discuss their individual chapters in whatever fora comes up to try to get their scholarship in the hands of those who can actually make a difference.
Well, we have a few minutes left, so let's talk about just a couple of those individual chapters. I know that there are people who are at the summit today who are also in the book. Let's just briefly chat about some of the work they did. So Stephen Smith is here, and he did a chapter on over-federalization. Yeah. What's the general idea behind that?
Well, Stephen's a real expert on the issue of federal criminal law. And he goes through and I of course, am giving my abstract of his very thoughtful work. But he goes through the federal system and calls into question how we have federalized so many different issues, taken what have traditionally been within the realm of the police powers of the states and have turned them into issues for the federal government. He does a really spectacular job of laying out the problems and then discussing the solutions, what steps we should take in the Capitol to try to roll back over federalization and perhaps prevent it in the future. So a really excellent contribution, and one that I think is very important here in the district.
How about Brandon Garrett from the University of Virginia? He's got a chapter in the book on actual innocence. What's that on in general?
Brandon is a polymath. He's written brilliant pieces in a variety of areas, but he is one of the nation's leading experts on the wrongful conviction phenomenon. And his chapter goes through and discusses what are the reasons why we have wrongful convictions, whether it is bad forensics or informant testimony or the failure to provide evidence as required by a good discovery system. And then he discusses, and again, at the end, this is, I think, important for all of the contributions, he talks about what kind of changes can be made to prevent wrongful convictions. Because, of course, it's far better to prevent them from occurring in the first place than having someone locked up who didn't actually commit the crime.
Well, we're out of time, but I want to repeat my most important question, which is how do people get a hold of the book?
It's available online, academyforjustice.org, and I am happy to talk to anyone about this topic, and I know my colleagues are as well, and excited about the prospects.
Well, terrific. I think we have to move on to our next session of breakouts, but I want everyone to join me in thanking Professor Erik Luna.